I welcome you all to the marathon for SBILL. Okay. Now, this marathon will be divided in two parts, that is today and tomorrow, and I will be covering the entire 40 marks for you. So, how much ever time is there, just be with me. I will be covering the entire part B for you all. Okay, in 2 days, the entire part B will be covered. Now, remember one thing, that the past exam questions is very important for this part. Okay, past exam questions, which is there on our website, and there the June 2025 attempt solutions and ICSI model answers are also there. Okay. Now, before I start, I will be talking about the amendments. Okay. What is there? Okay. Soumya, good to have you. Advait, nice. Let's start. Hi. So the labor laws have gone through a drastic change where the entire 40 marks of SBILL has completely changed. The labor laws have been repealed and now we have the new labor codes. So if we go to see, there are 4 new labor laws which have now been applicable, and it has been effective as well. And the 4 labor laws have consolidated all 29 labor laws that were there. All those 29 laws have been grouped into 4 labor codes. The first one is Code of Wages in 2019, Industrial Relations Code, Social Security Code, and the Occupation Safety Health Working Conditions Code 2020. Now, obviously, they were already made, as you can see, in 2019 and 20. However, due to industry responses, they were kept on hold. And now in 2025, they have been made effective. So from when they have become effective? They have become effective from your September month. Okay. Now the question comes that when will they be your November 2025 they have been effective. So is it applicable for your examination? The old labor laws are repealed. It is no longer there. It is applicable for your examination. Answer is yes. It is applicable and you have to study the new labor codes if you are giving your exams in June 2026 and onwards. If you're giving your examination in December 2025, then the new labor codes are not applicable for you. You have to study the old labor laws as given in your module as well. This was a question that many students were asking, that do we have to study the new labor laws? So take a breather and relax. The new labor laws are not applicable. So even the past exam questions are important for you. The module that you've received is exactly that you have to. With this, I conclude the part where this aspect of applicability of the labor law is concerned. So it is applicable from June 2026 attempt, not for December 2025 attempt. Just if you like this part, do like the video and put a thumbs up. And for June 2026, we will be starting the fresh batches in January. You can join there where the new labor codes will be discussed. Okay. So you all are happy that the new labor codes are not applicable to you? Yes or no? Yes or no, that the new labor laws are not applicable? So what happens is, understand one thing, that on basis of the part B, literally is so simple, the provisions are so clear, though the module has so much content. I will tell you which are the important things that you can do. You should know the main act, the key provision, and you're good to write the attempt. Now, second important thing is your past exam questions become very important for this thing, because to know that which kind of situational questions are coming, which provisions are they asking questions from. So I'll be covering all of those. Clear, good to go. Can I have GTG in the chat box? If you're watching it, do like the video as well. So I will be taking you and covering your labor codes from exam point of view, revision, that what comes in your examination, you can highlight and mark it with me. more or less the the notes are made from the ICSI study material. So you can do, in case you don't have these notes, you can mark it from the module as well. So can I have GTG in the chat box so we can start with the first chapter? We will be doing from chapter 14 till chapter number 20. 6 chapters, 40 marks in your pocket. Can I have GTG in the chat box? Hit the like button. Let me know that you're there so we can quickly begin. Yes, good to go. Shri, great to have you. Yes, chalo. Advait, good to go. Great. Let's begin. Hi, so we'll be starting with the exam revision for your lesson number 14, that is your constitution and labor laws. Now, before I start, let me tell you that lesson number 14 and 15 are not containing any labor laws. They are containing basically an overview, introduction of the and the constitutional provisions regarding labor law. So the questions from the examinations are very limited from these chapters. The questions that have come, all the past exam questions with the model answers, I have covered in the JT scanners which are available on the website. In case if you want detailed lectures, still it is available in a dream batch for all of you all. You can go ahead and complete your entire portion. In this part, I am going to tell you what you need to remember and highlight from exam point of view so you can complete it. Now, considering that you've studied your subject again. Okay, now let me take you. First, labor laws in India. In under which constitutional provisions are labor laws covered? Under which constitutional provision? So I am concerned with the constitutional provision, like for example your article 14, 15, 16 talk about labor laws. Again, if you go to see your further article numbers, you have your 32 to 26. This is about writ petition in case if your fundamental rights are violated. Further, with respect to employment, article or 23, 24, 25. Okay, all this we will be seeing. So the article numbers, whichever comes, we will be writing it. In this chapter, you need to know the key provisions and the article numbers which have come. So this is a article numbers from the chapter. Which are the article numbers? I want you to note down. So right now with me, this chapter will get over moment you know the article numbers and a few important case laws. So article 14. Okay. Article 14, 15, 16. What is it about? Tell me. You are giving also your group 1. So I'm sure you know your GIGL subject as well. So article 14, everybody knows, right to equality. Okay, equality before law. So everyone is treated equally. So there including the laborers. The constitutional provisions are there. Article 15. 15 talks about no discrimination in gender or religion, etc. Okay, so no prohibition of discrimination on the basis of religion, race, caste, gender, place of. Article number 16 is specific to employment, is specific to public employment. For example, government offices. Even in government office, no discrimination should be done in case of while being employing someone. So 14, 15, 16 is important. So these all the article numbers, if you are studying with me right now, just write. I'm going to tell you what comes in the examination. I want to take a book and pen. Lesson number 14 you write and the key provision. Then comes article 19(1)(c), which talks about a freedom to form associations and unions. So even they have with respect to labor laws, your entire trade union chapter comes from this article number, that you have a right to form your own union. Article number 21, 23, 25 or 24. Sir, what is this? Article number 21. This we know it is one of the most important. Right to life. Right to life. Any question that comes from this chapter, you have to start with the article number. Then comes article number 23. Very, very important. They have asked it in the examination also. Prohibition of traffic in human beings and forced labor. So here also they have law, the constitution has prohibited buying and selling of human beings. So that's called as human trafficking. Article number 24 talks about prohibition of employment of children in factories. We have an entire act made for prohibition of employment of children. So article number 24 then comes, see the number of articles that you need to know. Now all these articles till here were about part 3 of the constitution. All of this were about part 3. Now we're going to see part 4. Part 4 is the fundamental rights. That is, the state should try, endeavor, direct their policies to achieve these things. For example, a social order and welfare of the people. Okay. Then certain policies, that is directive principles of state policies, are given. Principles of such as standard of living, having a healthy environment, all of that is given. Article number 41, right to work, to education and to public assistance in certain cases. So right to work, right to education and right to public help in certain cases. 41. Then comes your article number 42. It is basically provisions for just and humane conditions of work and maternity benefits. So article number 42 gave right to your maternity benefits. Then 43 talks about living wage for workers. Now exam question was there from this chapter. What is difference between living wage and your basic wage? Living wage and your minimum wage. So minimum or basic wage is the bare minimum that one requires to survive. Whereas a living wage is basic to have the word a good living standards of living. So basically not only food, clothing, shelter, but all those things that make life meaningful. Article 43A talks about participation of workers in management of industries. Then okay, management of workers in industries, Factories Act, etc. has come from your Article 32 and 226, that is your writ petition. So all these article numbers you need to learn, and wherever possible you need to write. So again we take a recap. Article 14, 15, 16. 14 is right to equality, 15 is basically prohibition against discrimination, and 16 is basically prohibition against discrimination in public employment. Right? Then after 16 we come to article number 19(1)(c), trade union. So a person has a right or freedom to set up their own trade union. Then we will see the sequence. Okay, 21, 23, 24. 21 is what? Right to life. 23 is basically human trafficking. Okay, they have told who is a beggar, okay, or forced beggar. So basically any person who is required mandatorily to go and ask for money would come under the definition. So prohibition of traffic in human being. What does traffic in human being mean? Buying and selling of human beings. To buy and sell human beings. So that is prohibited. It is called as forced labor. Then 24 is basically a prohibition of employment of children in factories. Okay, then we come, these were all your part 3, now we're going to do part 4. Article 38, 39, 41, 42, 43. So 38 is basically that the state should work for a social order and welfare of the people. Article 39 is basically principles of to be followed. You have certain right to work. From here, at least few of them you will have to remember. Clear till here 32. 226. Then 227 is basically the right of high courts to supervise lower courts, and 136 is a SLP to the government. Is the concept clear? All the article numbers I have told you in the start, This is what you need to write. This chapter can come, one question can come from this chapter. So here, all your fundamental rights I have told you: 14, 16, 19, 21, 23, 24. Okay, prohibition of children working under the age of 14. And when you see directive principles of state policy, it is article 38. What was 38? Welfare of the people. 39 is equal pay for equal work. Okay, this is the directive principles of state policy given in article 38, 39. Equal pay for equal work. You have a equal managerial remuneration act that will come into play here. Okay, now from here, when you start with the chapter social justice and industrial laws, okay, and everything you don't need to learn, you need to just know the how do you start, frame your entire answer that the Indian Constitution through its preamble and article 38 states that the socio-economic justice as its primary goal. Article 39 states that it is the duty of the state to apply principles for social justice in laws. So the state should try to give social justice. Now the case law was given under State of Mysore versus Workers of Gold Mine. Very, very important case law. This you can write. Okay. Now I am telling that any question coming from this chapter, you have to relate it with the article numbers, quote the article numbers along with a few case laws. So you will say the Indian Constitution along with the preamble and article 38 emphasizes socio-economic justice as their primary goal. It is a duty of the state to give social justice. So obviously you have to memorize a few starters of how you will start your answer. Along with that, I expect you to write at least some case laws. This is one of them where you can fit in everywhere. So State of Mysore versus gold mines. What it has said that the importance of social and economic justice is important to uphold the rule of law and principles of welfare state. Means if we want to become a welfare state, it is very, very important to give social and economic justice. Now again, constitutional remedies. Now again, since we have done our GIGL, we would know what is article 32 and 226. Till here we would know, but also you have to further understand that there is one article called as 136 and 227 also. So you can write this down. Okay, your article 32, 226, your 136 and 227. Sir, what are they? Pay attention. If any person or workers fundamental rights are violated, they can also appear before the High Court under 226 and Supreme Court before article 32. Now even a public PIL, have you heard of the term PIL? So there is a case law which I will show you that a public spirited person can also file a PIL if he feels that a particular inhuman conditions are there or for the benefit of some people. So that also he can file. A PIL can also be filed for the benefit of laborers, for a class who cannot defend themselves. Then comes article 136. Article 136 is called as SLP. What it is called? Special leave petition. Sir, what is a special leave petition? Basically, now pay attention to what is a special leave petition. When you go from High Court to Supreme Court, the appeal, you require to file a SLP, special leave petition, that I am taking a permission of the High Court to go in appeal to the Supreme Court. So High Court gives a certificate of fitness that this case is fit to go to Supreme Court because it involves a substantial matter of law. So it can go. And then 227 is the power of superintendence of the higher court over the lower court. Like the seniors will look over the junior. So this is good enough. See. Now look at this case law. Okay. SP, which I just told you. Okay. SP Gupta versus some of the case laws you need to know. That SP Gupta versus President of India. What does it say? That opinion that if any legal wrong or injury is caused in violation to constitutional right, the affected person, okay, due to poverty, etc., cannot approach the court, then any public member can file an application in this on their behalf. So what does SB Gupta versus President of India say? Which I just told you the case, that if any person is labor class, right? So they are cannot affected person, their fundamental rights are violated, but they cannot approach the court. Then any public spirited person can file a special writ petition on their behalf. It is allowed. Okay. Similarly, even trade unions have locus standi. Even public spirited persons have local, on behalf of persons who are unable to represent themselves. So, what does locus standi means? It means a right to file a case. So, normally it is always a right to file a case is always only with the person who has on whom wrong has happened. However, locus standi, the right to file a case, is also given to a trade union representing a particular laborer, or even to any public spirited person, any public person who is working for the benefit of public, he can also file on behalf of affected person. Then coming to your fundamental rights and industrial relations. So we have seen all the fundamental rights in the beginning only, okay, which come under part 3. Then also we saw which come under part 4, all the article numbers. So which were they? So I will ask you, and how you will frame it in the exam, that the protecting and safeguarding the labor interest has been enshrined. How will you quote the particular thing, that the need for protecting and safeguarding the interest of laborers as human beings has been enshrined in the following article number. So the need for protecting and safeguarding labor laws has been enshrined in the constitution under article tuck 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 tuck. Here, as we discussed, equality before law, equal protection of the laws. Then a very classic case is there of Air India versus Nargis Mirza. It's a very classic case, and they have asked this in the exam. Not only this attempt, multiple attempts they have asked this same case law. Now what happened is, market is important. So he was a air hostess, okay. Now it was about air hostess. They said that, listen, Air India versus Nargis Mirza regulation. Now this is, you don't have to remember this regulation, but what did they say? Regulation 46 and 47 of the Indian Airlines was in question, that provided that air hostess will retire from service upon attaining the age of 35, or on marriage within 4 years of service, or on first pregnancy, whichever is earlier. Okay. So this kind of a law of an Indian Airlines saying that women will have to retire if they are pregnant went up to the court, and obviously it was held that the retirement of, so Nargis Mirza versus Air India, Indian Airlines, right? Air India. What did they say? That the retirement of an air hostess on the ground of pregnancy was treated as unreasonable and in violation of right to equality. Okay. So this is what you will write. So this case law I expect you to write in the examination. Now we come to article number 16. Sir, what is article 16? We've already done in constitutional law. That one thing is that this is about public employment. Can there be discrimination in public employment? Yes or no? So government offices, etc. Can you do public, your discrimination? So we all know that the discrimination is not to be done on basis of anything like gender, etc. But then they give you exceptions that maybe if we are trying to uplift a certain category or scheduled caste or scheduled tribe, then we can do some kind of, it's not a discrimination, but you could say that certain provisions could come. So nothing in the article will prevent the parliament from creating certain things to benefit a certain category. Okay, reservation of backward class, etc. Or if we are saying that from this area we will give preference, it won't be treated as discrimination. Okay, so they ensure that equal opportunity is given in public employment. Now coming to the next one is another important case law on which an act was passed. Okay, so if we go to see your Meva Ram versus AI aims. Okay, what do they say? That it is important clarify the doctrine of equal pay for equal work. Okay, if any classification is on baseline unreasonable, it would be treated as violation of Article 14 equality or Article 16. So anything happens, you can write that it is treated as a violation of Articles XYZ, and the appeal can go under Article 32 and 226. And in case if they cannot go, even a public spirited person or a trade union can go on their behalf. Okay. Then comes Article 19(1)(c). Now we've done Article 19(1)(c) also, that every person has a right to form their own associations, etc. Okay. See, in All India Bank versus National Industrial this, the labor laws. So they told that labor unions, that in a, labor union can be made, but it could not be made to purposely disrupt the operation. It is a means of collective bargaining and work between workers and employers. Now, while it is a fundamental right to strike is there, okay, we know that strikes can cause significant economic disruption. If all the employees go and refuse to do the work, it will cause a economic disruption. This is a right given to you, to all the workers, in Industrial Dispute Act. So they say that this is only justifiable if it serves a effective provision. So if the strike is legal, then the salaries are paid, but however unjustified and illegal strikes are not given protection, and the employee may not get remuneration for the time he has done the strike. Now in this case law, the right to form unions also means the right to determine and maintain its composition. Article 19(4) cannot be read just to justify any law that interferes with any association's voluntary composition. So who will be the chairman, etc. The working internal aspects also the government or the company cannot interfere. Right to life we've done, very simple. Okay, a right to life includes right to live in healthy environment. It is one of the most important fundamental rights. Now we will see Article 21, okay, which guarantees a right to life and personal liberty, has a very wide definition. The broad interpretation achieved in two major outcomes. So all these things can be considered to be right to life, that the state will ensure, okay, that they will give right to livelihood, medical air, live in prevention against sexual harassment, economic rights, medical care, etc. These are all directive principles. In directive principles, state will endeavor. Okay, so if they cannot, you cannot file a case. Implied fundamental rights. The Supreme Court has implied a number of fundamental rights for. So here in this case law, not important, but you can write it. Okay, dwellers. The petitioners were dwellers of slums and payment. They were issued an eviction notice by the municipal body. Okay, the petitioner contended that evicting them from their homes would deprive them of the means of livelihood. that the right to life ensured is given here includes right to livelihood. Okay, but you can still deprive a person if a proper process of law is followed. The Supreme Court held that evicting persons from the dwelling render them without means of this is tantamount to depriving them of a right to life. Now this is a very important case law in terms of, if today some slum dwellers are living for many years and you are just removing or breaking down their entire house, Supreme Court has said that listen, it is important to give them some kind of thing where they can survive. So that is why you see SRA Act are there, Slum Rehabilitation Act is there, where slums dwellers are rehabilitated into different homes. Let's see. Then comes a very another important case law from this particular thing, which is called as Vishaka versus State of Rajasthan. Now, this was a landmark judgment where the Supreme Court had stated that there are certain rules to be followed, okay, for all workplaces, that they have to have some kind of a committee, some kind of a redressal mechanism if there is a harassment for women. Okay, so this was a very big outcry that had happened, and people demanded that there has to be safety in work environment. After that, and on basis of this, the POSH Act was made, Prevention of Sexual Harassment, which is also in your syllabus, lesson 20. Okay, so they had told that certain kinds of that violation at workplace is actually a violation of Article 14, 15, 21. So Vishaka versus State of Rajasthan, that a woman was assaulted and harassed at a workplace. The Supreme Court said that this is a violation of the fundamental right and right to carry on any profession. Article 23 and 24. Article 23 and 24. So we had done, what was 23 about? Okay, so forced labor. Now market is important. Okay, Article 23 means prohibition of traffic in human beings and forced labor. So traffic in human beings and beggar. So they had asked the meaning of the term beggar. In forced labor are prohibited. So traffic means buying and selling of human beings, or making a person ask for money is treated as is prohibited. Okay. Exceptions: public service. Nothing in this article shall prevent the state from imposing compulsory service for public purpose. Like here they are saying that you can be forced labor means what? You cannot be forced to do work. But if we have seen in the new criminal laws, community service is added. So if you've done something wrong, as a measure of punishment, you are told that go and do compulsory social service. So that is allowed. Nothing in this article means that the state cannot do for reformative purpose. Article 23(1) prescribes that three unsocial practices are there: begging, traffic in human beings, and forced labor. Okay. Now Article 24 says prohibition of employment of children in factories. Now because of this we had the prohibition of children. Okay. Prohibition of employment of children in hazardous places. Now prohibition is given in article number 24. No child below the age of 14. So a child is basically below the age of 14. So 14 to up to 18, who is not 18. Okay, they can be employed in factories. They are called as adolescents. They cannot be appointed in any place which is hazardous. So below 14 is not allowed. And this article is also enforceable not only in private, in public government work, but even in private. Okay, so this case law had ensured that this, Employment of Children Act be passed, etc. Now, all from here, I want you to know important case laws and all article numbers. So you can quote if any question comes. Article 39, which is Directive Principles of State Policy, states that the importance of protecting children from exploitation and give them a proper opportunities and facilities to develop. Then comes labor laws with respect to Directive Principles of State Policy. Now, when we did above, okay, all of them were, article numbers for part 3, which is your fundamental rights. Right? Now we are looking at the part 4. Same thing we have done. We are just repeating everything. Okay, which we go to see as Directive Principles of State Policy. Now, what do you mean by the Directive Principles of State Policy? The state will direct their policy to achieve these things. These are the most ideal principles. And can you enforce, like how part 3 is not given, fundamental rights are not given in part 3, then I can go to the High Court and Supreme Court and file writs. But for Directive Principles of State Policy, these are not enforceable because state will endeavor to do it, make an effort to do it, but they are not bound to give it. Right? So we will see the article numbers which will come article 38, 39, 41, 42, 43. Okay. Now, your social order based on social economic justice. So here you have to write the article numbers. Article 38. State shall secure a social order for promotion of welfare of people. The first thing is the state shall direct its policy towards promoting welfare of people. Now, when I say welfare means what? So you should reduce in income inequality. Okay, give equal opportunities. Okay, legal framework for now this is about social welfare. And you have to give them a proper, justice, social and political justice should be given. Eliminate inequalities. Then comes legal framework for social and economic justice. Article 38, okay, of the Constitution's preamble envision that then always remember that they tell you in the start only, they have told that there is a trinity, okay, that the preamble, the constitution, okay, is there. So preamble also tells that you have to give economic and social and political justice to the people. Some of the case laws you can write to support your answer. Okay, fundamental right to health. So Consumer Education and Research Center versus Union of India. The state emphasizes that the right to health and access the medical care both during employment and retirement is a fundamental right. So you have a right to access the health both in employment and in retirement. Article 38 is always supplemented and must be read with Article 39. So let's look at article. What was Article 38? State to secure social order for promotion of welfare of human being. Welfare means what? The state shall try to work towards justice, social, economic and political. Reduce income inequalities, eliminate inequalities in status, etc. Now Article 39 is the Directive Principles of State Policy, where you see Article 39, where is equal pay for equal work given. So these are all 39 Directive Principles of State Policy. From here, which 38 part, which part talks about equal pay for equal women. So there is equal work for both men and women, equal work and equal pay. Now, this has brought in, as we have a separate act only, that equal pay and equal work. Bombay High Court has ruled that equal pay for equal work is a constitutional right goal rather than a fundamental right. So obviously it is not given in your part 3. So it's not your fundamental right in part 3, but it is a constitutional goal coming in your directive principles of state policy. So equal pay for equal work is a constitutional goal. In Randir Singh versus Union of India, the Supreme Court establishes that while equal pay for equal work may not be a fundamental right, it is undeniably represents a constitutional objective goals directive. Okay, and Article 39D says that equal pay for equal work for both men and women should be done. And because of that, we have a separate act on it. Okay. Now we're talking about a case law. Okay, National Campaign Committee for Central Legislation on Construction Labor versus Union of India. Sir, what is this? Very simple case law. Okay, what is happening is we are looking at the state's directive that the state is trying to direct to give welfare and equal pay, equal opportunities, so equal pay for equal work. So let's look at the case law. Okay, so some of the important case laws which are there. This is also important exam question. That's why I'm reading. The petition was filed regarding the non-implementation of the Building and Other Construction Workers Act, called as the BOCW Act. The non-implementation of this act and the CES Act. The petitioner argued that this act was not implemented, which violated the provision of the Constitution like Article 15, 19, 39F, 45, 47. Now, issue involved that if an act is not implemented, does it violate the fundamental provisions of the workers' right? So first we need to know that what is the law about. So this first let's understand this act and the CES Act are a social justice legislation designed to fulfill the directive principles of state policy. Article 39 of the Constitution focuses on health and strengthening of the workers, and Article 42 is concerned with the just and human conditions for working conditions. Article 21 says right to life is there for all. So this cess, when it is collected, it used to go for the welfare of the people. So when this is not collected, it is affecting them. So the conclusion is drawn that both so this you can just remember the final rule, that both these acts and the cess are crucial for safeguarding the dignity of construction workers. They must be implemented to ensure social justice and adherence to the rule of. So simple, these acts which were in benefit of the workers, construction workers, since it were not implemented, it was affecting their fundamental rights. So, and fundamental rights under equality, welfare, having in removing income inequalities, etc. Then we come to social security provisions. Now, Article 39, 41, and 43. How you'll write social security. In India, do we have social security? Do we have social security? I want to know from you. Do you have social security in India? So the answer is social security. Social security means that they will give you financial benefit if you've lost a job, or you have a retirement, or you are disabled or unable to earn. So social security is governed to provide financial support and benefits to individuals in times of need, such as retirement, disability, or unemployment. So that's called as social security. Now, social security in our constitution is given under, not in part 1, not in part 3, in article 39, 41, and 43. It is enshrined in these articles. So have you seen anywhere in our acts? Answer is yes. When you go to see all your Insurance Act, Provident Fund Act, Maternity Benefit Act, Payment of Gratuity Act, just remember the acts, Apprenticeship Act, Employment Exchange Act, all these acts are giving you what? Social security. So obviously you should know what these acts are, which will come in the other chapter. Just remember the name of the act. So social security is an integral part of the welfare state. So everywhere you get, you can write that India is a welfare state. In order to ensure this, social security is to be given. It is enshrined in our constitution under the following article number. Constitutional mandate. Articles in the constitution play a vital role. Article 41, 39, 43. Okay. 43, very important, that we should try to get a living wage. Living wage means not just a basic wage of food, clothing, shelter, but so that you can have a the way living comes from the word life. Standard of life should be good. So that is article 43. I believe you can always quote this in your examination. Okay. Article 43. 40, 39 we've done that equal pay for equal men, irrespective of the gender, equal pay for equal work. Multiple, this has been given in Article 39 directive principle, multiple of them are there. But Article 39D we had seen equal pay for equal work. Then comes Article 41. The state shall, within the limits of its economic capacity, state as much as they can, okay, should make some provisions for securing right to work, right to education, right to public assistance in case of unemployment, old age, sickness, disablement. First, so how it is structured? First, you have to write what is social, you have to write what is social security. Then you have to tell where in the constitution has been given that the state shall make, as once they get they have economic abilities, then they should give some right to work. Right now, this right to work is coming that in case of age of AI, multiple jobs are being lost. So there has to be, state has to give for unemployed people some kind of compensation, right? Old age, sickness, disablement, etc. And then pursuant to the constitution, multiple acts were made. All these acts we have in our syllabus. Your Insurance Act, Provident Fund Act, Maternity Benefit Act, Gratuity Act, okay, Apprentice Act, and the Employment Exchange Act. Then comes working conditions. Okay, now do we have any law that tells that the working conditions and regulates the working conditions? Any act? I'm asking you. So before we start, we have to tell under which the meaning that to have the working conditions in your offices, factories, and other places are regulated and are enshrined in the Constitution under Article 42. Now we'll see what is Article 42. So the state shall make a provision for securing just and human conditions of work and for maternity relief. So two things. So I want you to learn, okay, all these article numbers and quote it. 100% you will get an opportunity to quote. So you should have just and human conditions for working conditions, and second is maternity relief. Maternity relief. Now, so this becomes the foundation of the labor laws in India, that we have to give proper work conditions and maternity relief. From here, which labor laws have been made? Factories Act, Maternity Benefit Act. Okay. Then we are talking about minimum wage and labor wage. I have told you, very simple. This is asked in the exam also. Okay, living wage is covered under Article 43. So all the article numbers I want you to write down as I am teaching you. Okay, so those you can quote. Article 43 says that the state shall endeavor to give a living wage to all its workers. Now, what do you mean by the term living wage? Living wage is guaranteeing a decent standard of living, leisure, and social cultural opportunity. Okay, they don't just receive a minimum wage, but they are entitled to living wage. So Article 43 states that workers should get not only minimum wage, but they should get a proper living wage. So living wage means a person can not only have the basic essentials, but also education, protection against ill health, requirements of social needs, etc. Okay, minimum wage is just to support your food, clothing, shelter. So we also have an act called as Minimum Wages Act, that is there. Now, workers' participation in management. Now, what is this topic mean? What does this thing mean? That workers' participation in management. So you know your Trade Union Act, you know certain acts where 19.1, your provision of 19.1c, that you have a right to form your own union, and then you will participate, collective bargaining, everything is there. Factories Act tells about the strike, etc., which is there, certain schedule list. Let's see. Okay, so those you can quote. In addition to that, Article 43 says participation of workers in management of industries. The state shall take steps by suitable means to secure the participation of workers in management of their undertaking. You should hear the workers what they are saying. Through the amendment 43A, this is 43A of the Constitution, emphasizes the role of the workers in the management. So in this case law, the main grievance was that there was inadequate pay despite working full hours. The court held that part-time workers are regularized and full-time hours, they should be given the minimum scale as per the slots. Otherwise, it is a discriminatory practice. Whether the petitioner who are working 8 hours a day are entitled to equal pay as per Article 20 is, if not providing them with such amounts to discrimination. Part-time workers should be brought into full-time hours is what they are saying. Now state the provisions regarding labor enumerated in 7th schedule to the Constitution. Now again, we are studying only constitutional provisions. From here, I want you to write and quote this in the exam. Many students will not be doing it. That is the 7th schedule. So what is the 7th schedule about? It is about labor laws. It is about the provisions for labor. The Constitution has a clear delineation between the union and the states, we know. So basically the 7th schedule, okay, so 7th schedule is divided what is the state list, what is the union list, what is the concurrent list. In the 7th schedule, labor laws comes under concurrent list, so both the governments can make the laws. So union list, and these entries are given. State list, these entries are given with respect to labor laws, and concurrent list, these provisions are there. Okay, so where both the governments can make the. With this, we have completed the entire chapter where you need to know the constitutional provisions, key key case laws, and the 7th schedule few entry number. This is good enough to know the entire chapter. Thank you. Now we'll go with the next chapter, which is your lesson number 15. Till here it is clear. See, understand labor laws from this chapter which I did, 14th chapter. They will ask one question max. Okay, even from this 15th chapter they'll ask one question max. Okay, so I'll teach you how to handle it, and then the other chapters which are there, multiple labor laws, from there they really ask the provisions. Till here it is clear, yes or no? I want clear in the chat box. Yes or no? Clear or no? Ranjit, great to have you. Okay. Now I will start in 10 minutes the other labor laws. So we'll just take a. So then the next chapter that I'll complete is this labor laws part. Okay. We'll just take a maybe return back on 6:40. Okay, now understand, I am doing from exam revision. If you want a detailed lecture where every para is covered, I have also given it the access to you all in the dream batch. Okay, so hundreds of students have already joined. You can also go ahead and join. This is mean that in exam point of view, I just need a flip over these points. I will build my answer, done, and I'm done. Okay, so in the next thing I will start the 15th lesson 15 and we will cover. Okay. Okay, great. Shyam, great to have you. Okay, so we'll just return back. Till then, your job is to just go through the other chapters and brush up your skills. Maybe 14 and 15 try to complete in the next 15 minutes. Hi guys, so we start in a minute. Hi, am I audible and visible? Please let me know in the chat box. Okay, so let me know in the chat box if I'm audible and visible. We'll quickly start and complete this chapter. Okay, I need a thumbs up and a GTG in the chat box. I'll start and complete it, including all past exam questions. Remember, I have gone through all the past exam questions. I know what line of thought is there in the paper setter's mind. I've gone through all the past exam questions. Okay, so I need GTG in the chat box. So be with me. I will quickly complete the chapter for you. Quickly, guys, quickly. GTG in the chat box, and I start and complete the chapter. Advait, great to have you. Sham, great to have you. What about others? Let me know GTG in the chat box quickly so I can again complete this chapter for you, and this chapter will get over much faster. Okay, this is about the 3 labor codes. Quickly. Okay, great. Let's start. Hi. So we'll be starting with a chapter called as Evaluation of Labor Legislation and a Need of Labor Code. So what is this labor code exactly? So basically the labor laws, there were over 50 labor laws in India, and these laws have been consolidated or grouped into 4 parts. That 4 parts are called as labor code. Now this obviously, how did that labor codes come into play? It is your second National Commission on Labor Law. They had recommended that the existing labor laws which were there were so many 50 up labor laws. They said let's group it into 4 to 5 labor codes, and then after that it was grouped into 4 labor codes. So which are the 4 labor codes? Let's look at this. Okay, so all the labor laws which were there, they could be grouped into four categories related to code of wages. So in code of wages, all the laws with respect to minimum wages, all the laws with respect to payment of wages act, wherever wages could come, bonus act, all of that have been clubbed. If I would go to see code on social security, so social security meant like how in what does social security mean? That in cases of unemployment, in cases of injury, maternity, so all of that laws with respect to maternity benefit came under social security. Then came under occupational safety, health, working conditions 2020. So all the laws with respect to Factories Act, which covered this topic, have been submerged, or the correct word is subsumed into this. And the fourth one is with respect to industrial relations, like your employer-employee relations, where you have Industrial Dispute Act. So they got clubbed here. Okay. So now when we go to see the background, okay, of the labor laws, one is the ILO. So if they ask you, okay, they've never asked, and I don't think they will ask you, the ILO. Okay. Now the ILO was the first organization which dealt with the labor law, and they dealt it after the First World War. So moment the First World War ended, there was a lot of unemployment, poverty at a very large scale. Okay, uh, post the war. Okay, so then the ILO was established in 1990 in the Treaty of Versailles. Just a little bit of background. Then India became, so there are a total how many members? There are 187 member countries in ILO, and India is one of the key members of ILO. India is a founder member of the ILO and has been actively participating in the policy with respect to labor laws. Now, coming to the part where they said that now we need to all the Indian laws which were there, 50 plus act, they said let's merge it. They wanted to, they realized that there is a lot of multiplicity of laws. Now I'm telling you why the labor laws have come. These labor laws are effective from June attempt for your examination, but in 2025 when this video is taken, it is already effective. Only it has been effective in September. That is why it is not applicable in the December attempt examination. Okay, but the highlights of it is covered in this chapter, and what is the new part in the labor code, and what is the the highlight features which are there of the labor code, that we need to do. So coming back to what it is, as I told you, the second labor commission, they said that let's group it into 4 or 5 parts, and then it was merged. Then under which ministry this particular comes? Ministry of Labor and Employment. Okay, they submitted 4 labor laws where 29 central legislation, 29 labor laws which were of the central government have been merged into 4 parts. As we know now, your 4 labor codes. So at least the name of the 4 labor codes we need to know, and the highlights of each labor code. So code of wages, industrial relations, your security, social security code, and occupational safety, health and working conditions code. So obviously the name of the codes you need to know at least. Okay, that is very, very important. Then again, the very basic stuff, that what is the purpose of bringing the labor law or the need. One common answer you can learn with the heading you're done. So here they are not only telling what is the benefit of the new labor laws, but they are telling the new labor laws in general, general labor laws, how will it help. So obviously you have social security. So social security means in case if someone has an injury, someone has a loss of employment, etc. So what all social security India is giving. Okay, insurance, maternity benefit, or you could say your provident fund, insurance, all of that comes here. So promotion of a productive economy. So it really promotes, the purpose of a labor law is producing or having a good economy, having good industrial relations, and enforcing labor rights. The headings you can remember, which you can just write. Now we are coming to the main part. Is still getting into the 4 labor codes, which all acts are subsumed. Now this you can mark it as important. Till now it was just the concept which was there. So here if you just go to see, mark it as important. That in each labor code, which all acts are subsumed. Okay, so we will say these acts are subsumed in this code. Okay, code of industrial relations. So your trade union act, your standing orders act, and your industrial dispute act. Sir, what are these acts about? You have a separate chapter on each of them, so you don't have to really learn what is there inside of them. Right now you just have to understand what all has been subsumed. These acts like your payment of bonus act, wages act, all your minimum wages act have been subsumed in the code of wages. All this were there with respect to factories act. Okay, all this have been merged into the working this act. Okay, this code. So if you go to see how many labor laws were there were over 51 labor laws. Okay, now we come to the new objectives of the new labor code. Now this is a basic standard answer I wanted to make. Okay, where you will write, because it's not a law, etc. So just a standard on how will you start, which are the 4 labor laws. You write the effective date. You go check on Google the exact date when ICSI, when the government has implemented in 2025. Okay, you write that as thing and make your introduction set, including the objectives of the new labor law. So your start of a chapter has to be perfect. So in case if they ask even any labor law, highlights of any labor law, at least start off with the new labor laws. It has 29 labor central laws were subsumed. Okay, and write that the effective date of the labor laws. Clear till here? Then starting with the objective. Why was this labor law made? Objective means every act has an objective. So many acts were there, multiplicity of acts were there. So there were multiplicity of definitions. So they wanted to standardize the definition. Second, they wanted a kind of clarity on the definitions, terminologies, and consistency in approach. Means one act rather than 29 acts. Imagine getting registered in so many acts. Imagine knowing the definition of wages in so many acts. So might as well have one act, and when all the definitions have been merged. So they have consolidated the labor law, okay, which is there. Objective is standardization, having a in-depth coverage, minimum wages, industrial harmony, social security, health and safety. So obviously these were there in all the labor law: safety, social security, industrial harmony, minimum wages. So all that to do, gender equality, okay, having a better enforcement, all this. So this is theory part, not the main laws. Okay. Now coming to the each one. So again they have repeated under which code it has been subsumed. So this you can, I don't believe they will ask you. It is for your knowledge. I'll tell you what has come in the examination. What comes in the past examination, where they say the reforms of the new labor code. Mean now in the new labor code, what is new is they asking. So till now, whatever we did in the chapter was only theoretical, which is not exam oriented. Doesn't come in the exam. It's important to know the background, that listen, ILO was there, and then the second commission had told the labor laws to come. Then the 29 laws were subsumed into 4 labor codes, which all were there. You can remember highlights of few of them, etc. You write, and then we will be talking about 4 labor codes, and what is the new part is what they are asking in the exam. Okay, so first let's start and begin. A code was amended to consolidate the law relating to social security with the goal to extending social security to all the employees and workers, whether organized, unorganized or other sectors. To ensure that there is security for all the workers, central government has amalgamated the labor laws into social security code to ensure the right of workers for insurance, pension, gratuity, maternity benefit, etc. The government can fund the contribution of the workers for disadvantaged. Now, this I just read, but let me tell you what you need to write. The object of the labor laws. The object of code. This, so obviously out of 4 1 labor code they will ask you. I don't believe they will ask in the past exam also. Very few things questions they have asked. I don't think they will ask you in the examination. Okay, but we need to know. So how do you write? You write the history, a little bit of background, legislative background. Then you write about the code. In the code, for all of them, you will write it is a code to amend and consolidate the law relating to dash. If it is wages, then you write related to wages. If it is a law code on social security, then you mention about social security. Clear? This you will write. And the goal obviously is to extend social security to organized, unorganized and other sectors. And very important, you will say that in the social security you need to know what all is covered. So you would know that in social security, if I'm looking, social security, so all these acts are covered. So how do I guarantee that the social security is given? Social security means any time you are at disadvantage, so the government will help you. Social security is very strong in countries like Canada, that if you are unemployed, then they give you unemployment insurance salary. So here we have something like insurances, compensation act, provident fund, okay, maternity benefit, gratuity. So these are the common major acts which ensure that you are secure and you can live a meaningful or with life with dignity. Clear till here? Chalo. Now this is what you will write in the exam. Now we are talking about each code. So I want you to write the name of the code. I will be telling you what is new in it, and that is what is asked in the exam. In the past exam also, in your exam also. The code of social security. The code of social security. I have already told you, will write the object of the act. Object of act. Clear? You will write the object of the act. Is the code of social security is a law relating to consolidate and amend the law relating to social security in India. Its objective is to provide social security to all the employees, including unorganized sector. So what is unorganized? Basically where you don't have a formal employee, they are not formal employees. Like for example, your delivery boys, what happened, they are called as gig workers. Very important, separate definition has come, and they are also protected under code of security. Gig workers are when you are hiring beyond the employer employee relationship, okay, temporary purpose. This is there. And even the social fund established for gig workers. So gig workers is the highlight of this part, which they had also asked in the exam. Okay, so what is a gig worker, sir? What is a gig worker? So if you go to see, let's see. Yeah, so section 2 subsection 35 of the code of social security, they define what is a gig worker. A gig means someone who is not permanent, who is just a casual person that I have appointed. Okay, a person who performs work and earns from his such activity of his work outside the traditional employer employee relationship. So they are outside the traditional employer employee relationship. Means our employee will come every day to office and then go, so he will get a lot of benefits. But here what they used to do, they used to hire a delivery boy. So you have all these delivery apps, food delivery apps. Nowadays general apps are also there, so they're not into the formal employment, so they never used to get so many benefits. Now law is saying like, listen, gig workers are also employees, finish, give them proper benefits. So your fast delivery boys will come. Clear till here? Now, what all is the new thing that we will write? Okay, objective of the act has to be written. So any question comes, you will write the legislative background, where you will mention about the second law commission, the 29 labor laws being merged into 5, and then you will write the code, then you will write the object of the code, and then you will write the salient features. And then you will answer the main answer. Social security fund. Now government will make a social security fund, okay, will be established, where funds will be given to support the unorganized sector. Now I told you, now social security, what all we give, insurance, PF, maternity benefit, all those will come only. So those benefits, as it is from the law that you read, you will know, you can write it here. So those are the same things. Okay. ESIC Act, okay, Employee State Insurance Act, same thing that will be there. Okay, appeal provisions, etc., equal benefits. A database will be maintained, okay, even of the unorganized sector. A repository will be maintained. Now they are mostly focusing on unorganized sector. Organized are already, they are appointed, they get the benefits, and they are well disclosed. So the copy paste is there of the acts, but in addition what is new is what we are seeing. So a proper fund will be created where government will give grants, and then they will work for the benefit of unorganized sector. Here also proper database will be maintained, that who are the unorganized sectors employees who are working. Now online vacancy reporting. Employers with workforce exceeding 20 are required to post their vacancies online. So online posting of vacancy is important. So this is new. Universal account number. Sir, we have heard of permanent account number. What is universal account number? So especially that will be there. So we will come to know that if it is there, it can be used for multiple benefits. Okay, will be implemented for all the things and the benefits that are there, and will be supplemented by an Aadhaar link system. Means you will have a number, like how you have a PAN number, you will have from Ministry of Employment also a number called as universal account number. From that we will come to know how much PF you have, how much, where are you employed, what all this insurance you have, all those things will come. So it becomes what, good now, with one number I come to know all your benefits. So that will be made. That's it. Okay, then we are coming to the next one. So from the first one we saw that what is important is universal account number, online vacancy reporting, national worker base of total register of all the unorganized workers will be kept. Okay, rest all common points from the acts, health benefits, and social security fund will be made for unorganized sector. Clear? And also even all the benefits which are there, provident fund, etc., will also be given to unorganized, organized and unorganized sector. So that is the main crux of difference. Rest all, if you know the old laws, this is there in the new laws also. Copy paste. Same thing is given in the new law also. The differences is what is important for us to know. Second is occupational safety, health and working conditions code. Now, sir, again, I told you, any question that comes from this topic, you will write the legislative background, then you will come to this code, and then you will start with the object of the code. Every law is made with object of the act. And I've told you, object of the act, you just have to copy paste from the name. That is a code to consolidate and amend the law relating to copy paste with respect to safety and all of that. Then you will write everything with respect to Factories Act. Okay. Now, what is new? What is new, sir? Sir, what is the new thing that they can ask? So first thing is, under the labor codes, you had so many labor codes. So you had so many registrations done. Now what happens? There is one code with respect to this, like factories, you register there, so your registration is done. So all establishments, unification of registration. 100 registrations is not required. All establishments having 10 or more workers are required to obtain registration within 60 days of the code. Within 60 days of the code, they need to get registration. All requirements of health and safety are given to factories, all factories having 20 or more. So wherever you have 10 or more, you have to obtain registration within 60 days of the code, and all requirements of health and safety have to all factories having 20 or more. Now, coming to appointment letter and made statutory. Now the government has made a statutory compliance to provide a appointment letter. To provide a appointment letter to all the employees in the establishment. Now for you, you will say appointment letter and offer letter is always given. But was it given for unorganized sector, for gig workers? So now they are saying that that also needs to be done. Okay. Welfare work officer. Now this, if you read the current law, welfare workers are needed, okay, whenever there are 500 or more persons employed. But in the new code, they are saying that when 250 persons are only appointed, that time only you have to appoint a welfare officer. So this is the amendment, or you could say they made it more beneficial. So earlier only when 500 were there, I had to keep something of a separate officer for welfare. Now only if I have 250 also, I have to appoint welfare officer in the new code. Employment of women at night. Okay, so they have given the work timings and what you can appoint. So they provided that women workers are allowed to work between 7 p.m. okay, and 6 a.m. upon their written consent, and the state government shall ensure the safety and working condition, notify all. So women can be appointed at 8 o'clock, 9 o'clock, extension of hours can be given provided they get a proper safety. Government will appoint their safety and written consent. Now coming to the new part, what is new in this particular code? So what happened is interstate migrant workers. Now what does interstate migrant workers mean? You know, buildings, they hire people who will do the labor work, right? Picking up of the stones, etc. So they get them from other states. Laborers are imported in from another state. So they are called as interstate migrant workers. Migrant workers means the employer is hiring a migrant, a worker from another state. That is, so he becomes a migrant. So migrant workers is a worker appointed by our employer from another state, having a monthly salary of less than 18,000. Obviously they earn less than 18,000. Employer having more than 10 migrant workers must comply with this code. Okay, and they must have given all the benefits. So if you remember the word called as contract labor, there is a separate act also that we'll be doing called as contract labor. Okay, they will come under this category, and all the benefits etc. given even to the unorganized sector, and it is linked to Aadhaar card with a universal number, as we had seen. Now contract labor, Contract labor, I'll explain what it means, is now applicable to interstate migrant workers also. Who's an interstate migrant worker? He is basically employed from another state. The code applies to establishment having 50 or more contract workers, okay, on any day in the last 1 year. Now let's look at this. And a license will be given for 5 years. 5 years license to hire contract labor. Now pay attention. I will be doing an act called as contract labor. You have a law also, but just in case if you don't know who is a contract labor, there is a separate act. I'll tell you. So normally Ambani, I'll call him as a principal employer. Ambani, let's say, is into real estate. And he is building certain houses across the country. Now you think he really hires directly under him? Answer is no. He has a contractor. Who he has? A contractor. And the contractor further appoints contract laborers. So now how do you define? So the contract labor appoints the person, they are called as contract laborers. So this person who is appointed through the contractor. So person appointed by contractor are called contract laborers. Concept clear? I wanted to write it down. Person appointed through the contractor. Now what does law say? That listen, when you're hiring, they must be, I am hiring you and you're hiring further person, and this person could includes migrant workers, interstate workers. So they have come from another state and they are there. So what does the law say? That the primary responsibility to give them simple standards of living, salary, I'll call it as wages, giving them washroom facility, giving them staying facility, etc. Primary responsibility is of contractor. If he fails, then the contract laborers can go to the employer. So they are secondary liability. So only if the contract labor fails to give the promises to the contract laborers, then the contract laborers will go to the employer and ask for salary. This is mandatory to be given. Concept clear? So if anyone wants to hire contract laborers, you are going to have 50 or more such person, then you have to get a license, a contract labor license. Now law says, now this is a very simple case law and they had asked in the exam also, so let me ask you. Though this entire provision is in another chapter of Contract Labor Act, what they asked is, and this was clear also when they had given, that is it mandatory for the principal employer to rationalize the employment of the contract laborer? Sir, what does rationalize means? That means, do I need to absorb them, hire them into full-time employment? Answer is no. So there is no law saying that you have to mandatorily employ on full-time basis the contract laborers. By name itself, they are contract. Once the contract is over, they will leave. So further, after beyond the contract, nobody can force the principal employer to rationalize or continue the employment. Simple. That is logical. Okay. Now we come to the salient features. So in this salient features, I told you interstate migrant workers welfare. They have made that even they are covered under the Contract Labor Act, and contract labor says that if contractor is doing anything wrong, go to the principal employer. Okay, so that is covered. Employment letters are now mandatory even for unorganized sector. Health checkups, employers should provide free annual health checkup for all their workers. Construction workers benefit. Now very, very important, a case law was also there. Case law was also there on this, I'll tell you, which was there in the earlier chapter. So there is a act made called as a Building and Construction Workers Cess. A act made called as the Building Workers and Construction Workers Act and Cess. In that what happened, a fund was made. A fund is supposed to be made for the benefit of these construction workers. So all these buildings you see, all these constructions on the road, for them a particular fund government is making. Now implementation of this fund was taking a lot of time, so then it was said that listen, it is affecting the fundamental rights because they get directly benefited, and if they cannot appear, then someone in their public spirited person can take action that listen, make this fund, help them out, otherwise it is affecting their fundamental rights. So this is a ration card facility. So one nation, one ration card will be there. Because earlier what used to happen is ration card could be very area specific. So if I'm gone in another area, I would not get the benefit. So now they said one nation, one ration card, irrespective of the geographical area that you are placed. Okay, helpline will be there for migrant workers. So this entire new part is migrant workers here. A mandatory helpline number will be there for them. A national migrant workers database will be there. Now further if I go, what is the new thing? Leaves. Reduction in the requirement of work days from 240 to 180 for leave eligibility. Currently in the current laws which are there, Factories Act, etc., which were the before the labor code, 240 days was required to get a leave. Okay. Now they said no, not 240 days, in 180 days you are there, you will be eligible for leaves. Okay. For every 20 days worked, 1 day leave in entitlement. Okay. For every 20 days worked, 1 leave entitlement. Then we come women empowerment. Emphasis on women empowerment is there through these codes. Right of women workers to work, everything is there. Now one very important thing, maternity benefits. Now obviously we know the maternity benefits that is there is similar here, but something extra is there, I'll tell you. Provision of 26 maternity leave is there, giving them creche facility. Creche is basically where very newborns are kept. Okay, so factories need to do, and it is exactly same here also. So if you've done your Factories Act, you can write it is there in the new code also. In the new code, everything is same as the earlier law, only differences we need to know. A national advisory board was made. Okay, state advisory board has been made. Safety committee needs to be appointed. One point we can say, I don't think they will ask you that epidemic provisions. Now after COVID, almost everyone is saying that government will make provisions and a special grant to deal with things such as epidemic, pandemics and other disasters. Now we come to the Code on Wages 2019. Code on Wages 2019. A code on wages, again, we would write, if any topic comes, we will first write the legislative heading, legislative background or legislative history, and in that you will write the ILO if you want. You write, make one common answer where the legislative history will be there. For any of the 4 labor codes, that history will be same. Then you write about the labor code. The object of the code is to amend in the law relating to wages and bonus. Okay. So which are the labor laws which are there? Your Wages Act, when it should be paid, minimum wages, bonus, equal remuneration. Every act has been copy pasted into the code as it is. New points we need to know will be highlighted. Okay. So objective to the law, so a uniform single definition was made of wages. Uniform single definition has been made. Then one new thing that they have asked, which they can ask you in the exam, because that's new. Okay, so they have asked what is a floor wage has been, the concept of a floor wage has been introduced. Do you know what is the meaning of floor wage? It is different from minimum wages. Floor wage is different from minimum wage. This is something new. This is new. Fixation of floor wage. This is new. Can you tell me what it is? So very simple. What they have said that minimum wage is the bare minimum that you have to give. Now it depends on which industry you are there. For every scheduled industry, a different minimum wage is there. So if I'm working in a factory of manufacturing of cars, it will be different. If I'm working in a pharmaceutical company, that will be different. If I'm working in a shoe shop, it will be different. So minimum wages differs from sector to sector. Whereas what floor wage they have said is the minimum per hour wage that has to be there. So this is sector specific. This is sector specific. Sector specific. So they have said that listen, no matter which sector you find, no wage can be below the floor wage. So minimum wage, maybe for whichever sector you use, can never be below the floor wage. So this we will see when we come to the definition. Okay, equal remuneration for equal pay is same as the act. Nothing new here. Minimum wages under the code. We know what is minimum wages. There's a minimum, pay that has to be given for that establishment, for that schedule, for the sector. Now let's read the floor wage. Floor wage was introduced. Okay, it says it takes into account the minimum standards of living. Based on the floor wage, the government are to fix the wage rates. The minimum wage are also cannot be lesser than the floor wage. This is the most important line. That floor wage is looked at the standards of living, minimum standards of living, and they will fix it. The minimum wage can never go below the floor wage. Finish. Rest all is simple. Okay, now salient features again. All the points of bonus, everything is the same. You will review it in 5 years. Equal pay for equal pay. Rights to unorganized sector. Let's see if anything new. Same thing is there. Then comes industrial relation code. So again you will write the legislative history, then you write the object of the code is to consolidate and amend the law relating to trade unions, etc. Okay, and which all laws have been amended? Your industrial dispute acts, etc. Now what is new? What is new in this? That is important. And they have asked what is this reskilling fund? Now this I had already told it is very important. Now, and this also I'm telling you, they have not asked this, but they can ask you. That strike, we know strike is refusal of work by the workmen in the current organization. Now, doesn't amount to termination or resignation. They are not leaving. They are just denying to work till their demands are met. It is a means of collective bargaining. Now, one of the type of strike they have said that everybody has taken a leave on the same day. So what have you done? Where more than 50% of the workers have taken a leave taken by more than 50% on a given day is also considered to be strike. How is it possible everybody is applying for leave on same day? So it looks like a consorted, so includes consorted casual leaves. It includes what? All of them have collectively decided to take a leave. Okay. Reskilling fund, most important part. Reskilling fund means what? Now, when a workman has been retrenched, sir, what do you mean by retrenchment? I've always told you have to know 4 definitions in your Industrial Dispute Act. That is strike, lockout, retrenchment, and layoff. And so 4 things are mandatory to be known. So what is a strike? It is a refusal to work by workers. They are saying we will not work. Lockout is a refusal to employ. Refusal to employ. By whom? By the employer. Right? Retrenchment and layoff. Layoff means due to business issues. Okay, you are unable to work on that day. So no SAM. No SAM is the keyword. I don't know whether you know it or not. So when any natural disaster is there, there is overcrowding, there is shortage of work supply, there is accumulation of stock or breakdown of machinery. So business issue is there. There is no dispute or issue. Okay, and it is you are not removed from the company. Whereas in all these 3 you are not removed. Only in one category you are removed from the company. Here in retrenchment you are removal of an employee, or workman, okay. but not disciplinary, not due to disciplinary reasons. Sir, why? I mean, disciplinary reason normally you would remove. So layoff is what, light has gone away. We tell everybody go home today. It's a layoff because the light has gone, electricity is gone, power supply is not there. Come back tomorrow. So here nobody is removed. Here also nobody is removed. Here also nobody is removed. Only here there is a removal of employee or workman. Now, why are you removing? That is also there. Not due to disciplinary reasons. It's not due to that or retirement. Not because of that also. Not due to disciplinary reasons or retirement. It's not that someone has taken a retirement and that I am removing. I'm removing maybe because now I have brought and that is what is going on in the business. You could say in the practical world today. They are employing manpower softwares. A manpower AI software has been inbuilt which does the work of 50 employees. I've incorporated a particular software and that software does the work of 50 employees. So I don't require those 50 employees. They didn't do anything wrong. They are not retirement. They are not on the retirement age. But I don't need them anymore due to business reasons. And that is removal of employee. So this is called as retrenchment. So now due to the COVID and everyone incorporating AI, people are being removed and unemployment rate is very high. So there they are telling the company that listen, you're being, you are removing a person. So we will set up a reskilling fund. What we will set up? A reskilling fund and give him reskilling allowance that you please go learn something and come back. So the code provides for setting up a reskilling fund for workers who have been retrenched, removed from the company. Okay. Now they have defined worker who means who are having wages up to 18,000 rupees. Okay, what is important? Let's see. Now, very, very important. Okay, because people are being removed in today's time also. So pay attention to both these points. Okay. Past exam question as well. That retrenchment provision. Upon retrenchment, worker are provided 15 days wages for reskilling. So whatever was your wages, 15 days extra we will pay you for going and reskilling, upskilling yourself. Then Atal Bimit Kalyan Yojana. It provides financial aid for job losses in sectors under the ESI scheme. So two things it is there. You have to remember that if today any employee or workman is removed, he can go up. He can go up to the get 15 days salary for retrenchment and basically under this yojana as well. Okay. This is the most important part, and that is it. We have completed the entire chapter, including the past exam. Thank you. Clear till here? Yes or no? Write clear in the chat box. Write clear in the chat box. So I have completed this entire chapter. I have completed this entire chapter. Write clear in the chat box. Okay. Clear? So we are done with lesson 14 and 15. Okay. So 14 and 15 we have done. 40 marks we should get it in our pockets. Okay. Covering everything including the past exam question. Now we are doing lesson number 16. Lesson number 16, which is contract labor and the Factories Act. Contract Labor and Factories Act. Clear? Advait, great. Ramakrishna, great to have you. Now we'll start with these two chapters. Okay, so we'll take a 5-minute break and we'll come and we'll complete this entire topic. Okay, 5 minutes and we will come and complete this entire chapter. So 5 minutes. That's it, not much. Hello. Hi. Okay, so am I audible and visible? Can you please tell me in the chat box? I'll complete the chapter for you. Just let me know in the chat box if I'm audible and visible. So I will complete this chapter for you. Okay, just write GTG in the chat box. Okay. Ramakrishna, great to have you. Okay. And also remember, the Dream Badge gives you access to all the lectures. Please go ahead and enroll if you have not enrolled. It is immensely useful. Okay. Advait, great. Let's begin. Hi. So we'll be starting with a chapter called as Contract Labor Regulation and Abolition Act 1970. Now, who are contract laborers? So contract laborers are those who are employed through a contractor. So there will ideally be three parties. There will be three parties. Okay. The first party is your principal employer. Is your principal employer. I'll tell you what is the object of the act, everything very easily. Then there comes a contractor, and under the contractor comes contract laborers. Contract laborers. Okay. So who is a contract laborer? I want you to write a contract laborer is a person who has been appointed through the contractor. So the law covers contract laborers. So they are on the lowest level of employment. So law, in order to protect them, okay, regulates the working, and in certain cases they will prohibit appointment of contract labor. Now, in regulation, they have very simply said that it is first the primary responsibility of the contractor to give them basic level facility. If you see the roads that are being made, the building construction, so they are normally contract laborers where a contractor hires them. They give them basic washroom facility, toilet facility, first aid kit, these facility, and their wages have to be paid. In case if that is missed, then it will be given by the employer. The employer can then recover this amount from the contractor either by deducting the amount to be paid to him or through a as if it is a loan. This is the simple little provisions, and in contract laborers there is no requirement for this principal employer to absorb or regularize this contract laborers. Means you don't after the it's only for contract purpose. Once the contract is over, they are removed. Let's see. Now coming to the point, Contract Labor and Regulation Prohibition Act. The object of the act is to regulate contract laborers. So, and this also they have written in the always the start of your answer has to be perfect, especially for labor laws. You can write a case law also that in Galmin India versus Union of India, the object of the act is to prevent exploitation of contract laborers and to introduce proper condition of meaning of contract labor, as I've told you, those who are hired to through a contractor. Those who are hired through a contractor are called as contract laborers. Now, what is the responsibility? The responsibility is to give them proper salaries, and this act applies to every contractor who employs 20 or more workers. So, whenever contractor appoints someone contract laborer, that person will be called as contract laborer. And whenever 20 or more is there, this act applies. You have to get a license, okay, which is there. A proper register has to be maintained of the contract laborers. The contractor is liable to pay canteen, restroom, and first aid facilities. Okay, this is the primary responsibility of the contractor. If he fails, on failure, the principal employer will become liable. This is the main provision of the act. Then there is a case law which they had asked in the exam that do they have to absorb the contract labor as a regular employee. This was the last exam question. So in Steel Authority of India, common sense, you don't have to employ, okay, and tell them to mandatorily employ. advisory boards will be set up. Always advisory boards advise the central government. State advisory board will advise the state government with the point of contract labor. Now, whenever you're appointing 20 or more, then the contractor has to get himself registered, get a proper license. Okay, and this license can be revoked also. Now, prohibition of employment of contract labor. Now, obviously, in certain industries where they feel that it is unsafe, etc., government has kept a power to prohibit it completely. That they will notify in the official gazette after looking at the conditions of work, etc. Not that important. Inspecting staff. Now, inspector government has appointed, which will have a right to enter into reasonable premises, examine any contract laborers, seize any copy register which is there. Okay, and if any person is unhappy with the decision of contract laborer or the inspector, they can go in appeal. Okay, the small chapter is. Now we'll start with a important chapter. So we'll be starting with the chapter called as Factories Act. Now, Factories Act, you need to understand what is a factory. Then only this act will apply. And if this act applies, what all does it cover? So if you just think that someone working in a factory, what all would be there? In a factory, there are dangerous equipments, machinery, etc. So this object of this Factory Act is to ensure that there is proper safety, promote health and welfare of the workers. So 3 words I want you to learn as the object of the act. For labor law, every single labor law you can write that it is a labor welfare legislation. You start off writing that it is a, what you will write? That it is a labor welfare legislation. That it is a legislation for the benefit of labor. 3 things will be given. What 3 things will be given? So safety, health and welfare. 3 things will be given under this act. And further about annual leaves, when the leave will be given, and appointment of adolescents. We will see what it is. But the main act is about giving them proper workers proper safety, promoting health and welfare. Okay, and this also I want you to write that it comes under the ministry. All your labor law comes under the Ministry of Labor and Employment. Now, moving ahead to the scheme of the act. The act consists of 120 sections, 3 schedules. So, Schedule 1, Schedule 2, Schedule 3. It tells you which are the certain diseases, occupational diseases, some levels of chemicals, and contains a list of hazardous processes. Do you have to learn? Answer is absolutely not. What is important? Let's look. The meaning of the term factory, because only if it is a factory, then Factories Act will apply. So factory means what? First, there has to be a premise. Premise means a location, having boundaries, everything. Okay. If you imagine a factory, you will see that there is enclosures, and inside that the manufacturing process will go on. Including the present means including the surrounding area. So factory and its if I see a building also, there will be some open spaces, that is also included. And in the factory, manufacturing process is being conducted. Now, for manufacturing processes, with the aid of power, if 10 or more workers are appointed on any day in the last 12 months. So, with the aid of power means there is proper power required to manufacture the product, and 10 or more persons are appointed in the last year any day. In fact, you are a factory. If it is without the aid of power, for example, handloom industry, where from they stitch. Now, what is a manufacturing process? From raw materials to finished goods. You don't need electricity for handlooms. Okay, so very rare, but those industries also there. So that will be treated as a factory. So for example, there is tailoring, there is stitching, etc. going on. Cloth is being made into proper dresses. No manpower, no power is the electricity is there, but not power to manufacture the product. Right? So if there are 20 or more, any day in the last year, it will be treated as a factory. Simple. Very simple. Okay. Now, So the meaning of the term factory requires a premise. It must be a manufacturing activities, 10 or 20 people depending on power is there or no. And the following are not covered under the definition of factory. Why, sir? Railway, shed, mines, mobile of armed forces, eating restaurants. Obviously, when I make a fried rice. I have cut the vegetables, raw materials, and I made a finished good of this. It's obviously a restaurant cannot be treated as a factory. Okay. Armed forces, obviously, it is a separate thing. Mines and sheds, etc., they have a separate law altogether for them. So, Factories Act will not apply. Rest everything, Factories Act will apply. Clear? Let's look at other things. Okay. Now, what do you mean by manufacturing process? So, manufacturing process is basically converting a raw materials into finished goods. However, here they are saying manufacturing process is an inclusive definition. That it includes doing all these things, okay? Oiling, alteration, these are all manufacturing. If I'm saying a manufacturing process going on, with the painting work, pumping, generation of power, printing, construction. Now, this you don't need to remember, but all this is also treated as manufacturing process. Now, adults are allowed to vote. So, this every single person will know the meaning of the term adult who has completed 18 years. Okay. Child is a person who has not completed 15 years. Okay. Young person is a person who is either a child or adolescent, and adolescent is a person who has completed 15 years but has not completed 18 years. Now, for the purpose of Factories Act, this threshold needs to be 18. I understand, but what if someone is, let's say, less than 15? Okay, then he is a child. If it is 15 years is completed to less than 18, then he is a adolescent. Okay? Adolescent. And then if I say is a young person, both of them are young person. So young person includes a child and an adolescent. Concept clear, very simple, easy to go. Let's move ahead. Now another thing is occupier. Very, very, very important. Understand the meaning of the term occupier. Occupier means if Ambani has 20 factories, you think he is the person who is ultimate control of the factory? He is the owner of the factory. Owner doesn't come, he might have thousands of factories. There is a person appointed who has a control over the factory, immediate control over the factory. So they are called as occupier. In law, you will see that the occupier will do all the return filing, incident reporting. If there's an incident, if there's a death, he has to do all that responsibility. He has immediate control over the point. The important test whether a person is occupier or not is a possession, is a, who has the ultimate control. Supreme Court in JK Industries versus this has said that only a member of the board of directors can be an occupier of the factory. The ultimate control of the factory rests in the board of directors. They will have to tell that who is the person who is in charge of running that company. An employee of the company or a factory cannot become the occupier. They want a proper BOD, board of directors, who has ultimate control or deemed control. Hazardous process. So they say, why is this point given? That a child is not allowed to work at all. Young person can work in so a child who is below 14 is not allowed. Young persons are allowed to work, but not in hazardous processes. So hazardous process means in the schedule they have covered a certain list of activities which are considered hazardous. Okay, and hazardous would mean that they can cause impairment to health, okay, or result in pollution in the general environment. Okay, now we come to some part statutory agencies. So certain under the Factories Act, there are certain authorities that have been created for them. One is a inspecting staff. Okay, the government will have, central state government will have some inspecting staff who will come, inspect, take samples, understand whether it is right or wrong, and then if there is anything, so they will be the first officer in contact. Okay. Then comes to the next thing is uh, certifying surgeons. Now this is coming for persons if you are hiring young person. For example, that a young person, if he wants to be appointed into the factory, he can be appointed, but he requires a certificate of fitness from a doctor, right? A certifying surgeon. So this is only for young person. They will certify whether he is fit to be employed in that organization or not. So these certifying agencies will examine and certify, give a certificate of fitness whether this young person can work in the factory or not. Very important, safety worker and welfare officer. Now this sometimes they ask in the examination because there is a number given. You're 500 or more, you're 1000 or more. So whenever in any factory, if there are 500 or more workers, then a welfare officer is to be appointed. Okay, and it is the obligation of the occupier to appoint a welfare officer. If I see a safety officer, then it is whenever 1000 or more are employed, double of the number, then a safety officer separately has to be appointed. Now, notice by occupier. Very important, okay? Notice by occupier. This is given under your section 7. Now, what does it say? That the occupier is a person who has the ultimate control of the factory. He has to be one of the board of directors. Moment he has got control, he will write a letter and tell that I have given notice to the government and listen, I am the occupier. I am the one controlling this factory. If there is any incident, he will have to tell. When the factory has been shut down, again he has to tell. That's all. Topic over. So impose an obligation on the occupier to give a written notice to the chief inspector at least 15 days before an occupier begins to occupy the premise, at least 30 days before the resumption of work in case of seasonal factories. The normal case is 15 days. If it is a seasonal business, then 30 days. If a new guy has also been appointed, new occupier is there, whenever a new manager is appointed, the occupier shall send a notice to the inspector, a written notice, the chief inspector within 7 days of taking charge. Duties of the occupier is to ensure, though the duties they've given you, but it will always be 3 things only. Where you will see in the law, 3 things will come: health, safety, and welfare. So all the 3 words will be there: health, safety, okay, and welfare. Every occupier shall give health, safety, and welfare, and what they will do in health, safety, welfare will come in sometime. Okay, here now is the most important part of the chapter. Now this is the most important part of the chapter. So anytime they ask you anything in the chapter, you will write it to the welfare, labor welfare legislation. You will write, that it is for health, welfare, and safety of the work. Now we will see the in health. In health, you can have a fast reading. They will ensure that there is proper cleanliness. Now wherever you see a number, I'll make you mark what they can additionally ask. You have to ensure that it is clean. I'll separately mark. That interior wall should be clean. Every once a week it should be once a week the floor should be thoroughly cleaned. Okay, effective drainage mechanism should be there. Now, interiors of the wall are kept clean. Whitewash has to be done once in 14 months. Where the surface has been painted, repair should be done once in 5 years. Doors, windows, etc. should be clean. There has to be proper disposal of the waste. Ventilation should be done. Dust, fumes, humidation, overcrowding should be prevented. That means a minimum working space of 1.4 cubic meters per worker. Whichever I'm highlighting, that you can remember. Rest is general stuff. Okay. Lighting facility should be given. Drinking facility. No such point should be situated within 6 meters of any washing or urinal. Means drinking Water should not be 6 meters of the urinal. Okay, where there are 25, 250 or more, proper cool drinking water should be given. So just take a note of the thresholds. Rest all you can write in your own general words. Latrine now, and urinal, wherever there are 20 to 50 workers ordinarily employed in a factory, additional measures should be given. A proper sanitary should be given. Tile should be clean. uh, Once in 7 days it should be clean. Spittoons. Yep. Now this is they've given you, so just headings you can do. I'll tell you what is important. Huh? Till now, just own meaning you can learn. So you see here, cubic meters. They don't ask all this, but still, one seat for 20 workers, washed in every 7 days. This highlight you can go. Floor wash should be once a week. Sweeping should be done every day. Doors should be painted in every 5 years, etc. So till now, nothing as such has been coming done. A general headings you do is sufficient with internal lines. Now we come to safety. In safety also, what we are saying, fencing of machinery. So machines have proper fencing so that there is no injury or safety issue. Prime mover, is there any moving parts are there, they have to be properly protected. Protection of eyes. Okay, they have to give suitable goggles for protection of a person's eyes, okay, wherever manufacturing process is being conducted, so that there is no risk to the injury of the eyes or the vision. Now what is important? Safety officer, extremely important. 1,000 or more is there, they have to appoint a safety officer. And welfare officer, whenever, how much? 500 or more welfare officer should be done. Ambulance room should be done. Let's go in order only. Welfare, washing facility, first aid, very very important. So only where the thresholds are there, write that. Rest all in general words you can write. So at least one first aid box should be there for every 150 workers. Very important. Numbers are important. Ambulance, wherever there are 500 more, an ambulance room should be provided. Canteen again. So 250 you require. At 250 and 500 there are multiple things to be done. So canteen, wherever 250 workers are ordinarily employed, they will have to have a canteen facility. Shelter room, again rest rooms and lunch room. Where 150 workers are there occupied, they should make an arrangement for proper shelter, or lunch means basically place to relax. So I want you as of now to take a book, pen, all the numbers, write it down, make 3 headings. One is for health, welfare, safety. General headings you can write, and write it, everything in your own line is sufficient. Threshold, just remember. Crutches, very important. Wherever there are 30 women are ordinarily employed, they should be crutches should be given. Where under 6 years, where children could play. Crutches is basically play area from infants and small children. So in every factory where 30 women or more are employed, proper room should be given where under 6 years children could be there. Okay, women are trained in case of children and infants should be in charge of such. Welfare officer, again wherever 500 or more are appointed, welfare officer is to be appointed. Okay. Then we are going to do this Child Prohibition Act. Okay, very simple, very easy. Hardly anything is. Okay. Now, hi. So we'll be starting with the Child Labor Prohibition and Regulation Act. Now the definition of child is differs from act to act, but for this purpose, article, child is a person who is below the age of 14 years. Very important. Child is is a person who is below the age of 14 years. And as per our constitution, okay, no child below this 14 years should be appointed in any factory or hazardous employment. So, as per Article 24 of the Constitution, no child should be appointed or employed. This is very important. I want you to write whenever this act, anything comes from this act. One. Second, you will also still quote the Constitution. Okay, 3 constitutional provisions you have to write. 3 constitutional provisions. Article 24, Article 39, and Article 21. Okay. So what is it? They are talking about Article 39. State shall direct its policy to ensuring that the children are not abused and misused and not forced by any economic or financial necessity to enter into areas which are unsuited for them. So this is Article 39, that children below the age of 14 should not be pushed into or forced into due to financial necessity into areas which are unsuited for them. Article 21A, this is all related to children only. Okay, state shall be entrusted with the free and compulsory education to all children below the between 6 to 14 years. So with respect to child, what all provisions are there? We saw Article 24. What does Article 24 say? That no child below 14 should be under hazardous employment. Article 39, what do they say? That you should not be forced into anything which is unsuited for them. And Article 21 says compulsory education between 6 to 4. Further, we can say that in view, write this line, okay? In view of these constitutional provisions, your Child Labor Prohibition and Regulation Act 1986 was passed. Okay. So not a very great joke, but come, let's go to the next part. Okay? So now we are coming to the section. Now my question to you, can you employ child less than 14 anywhere? There are exceptions. You know that entertainment industry and all these dance, India dance, or you see all these talent shows, children below 14 in all these television shows. So 2 places it is allowed. Entertainment industry allowed. You see children who are diaper ad, they are making them sit diapers and they are telling that, this diaper, that diaper is given, then the child is below what? They are below 1 also. Appointed, okay? So exception, entertainment industry and family business allowed, rest nowhere allowed. Let's read. Prohibition, directly prohibition of employment of children in any occupation or process. So let's read. Section 3 talks about prohibition. No child shall be employed to work in any occupation or process. So no child should be employed. Except, I told you 2 places. Except family business and entertainment industry. Finish. You see all this is there. Okay. Can this be done for entertainment purpose? However, they are just saying one line that however, no such work should be that the school education is affected. Okay. Now we are coming to, so child, it is over. Only two instances where they can earn. Okay. Then comes prohibition on adolescent. Now adolescents are not children. So above 14, now for Factories Act is different, for here it is different. Okay. Here the child is 14 years and 14 and not completed 18. So adolescent is there. So under section 3A, no adolescent. Adolescent can also be employed but not in hazardous processes. See, shall not be appointed in any hazardous. So remember, child cannot be appointed in hazardous process. Sir, what is hazardous? I want to appoint a child for something. Is it hazardous? So the schedule has given whether it is hazardous or not. Very simple. They have clearly mentioned. Okay. So the hazardous processes are mentioned like mines, anything which is explosive, and hazardous processes. Hazardous process shall have the same meaning as in the Factories Act. Hours of work. So day and night I can make children work. Answer is no. Let's see for how many hours they are there. They can be appointed. Okay. So we'll come. Market is important. No adolescent shall be permitted to work between 7 p.m. to 8 a.m. in the night. Not night shifts not allowed. No adolescent shall be allowed to work overtime. No adolescent shall be permitted to work in any establishment on a day where he has already worked in another establishment. So if I've appointed him in, he's already finished one, he cannot go to the other. So it doesn't happen that I cannot appoint him, two times for, money. They might try to do two jobs, so not allowed. Okay, so this all is there. Then they are saying, very important. This is very, very important to know this section. Okay, because this is the core provision. Child to cannot be appointed, but adolescent can be appointed. Okay, now we'll see few more conditions. The period of work shall be fixed and it cannot exceed 3 hours. Okay, they will appoint for max 3 hours. Okay, then comes no adolescent shall work for more than 3 hours till he gets a rest of 1 hour. Okay, 3 hours, maximum 3 hours work, then 1 hour rest. 1 hour, write it down. The period of work shall be so arranged, again further, the period of work shall be so arranged that it shall not spread for 6 hours, okay, including the time spent in waiting for any day. Means max 6 hours in a day. Max 6 hours. So 3 hours work, 3 hours he is worked, 1 hour break, max total 6 hours. So you can say max 6 hours. So here I'll just take a 3 hours work, 1 hour, and overall 6 hours. Okay, very simple, easy. Weekly holidays, so a full week in one full day should be given, a holiday should be given of one full day. Notice to inspector, so whenever anyone is employing any adolescent, within 30 days they have to inform the inspector, maintain a register, and that's it. Okay, penal provisions, and that is it. We've covered the entire chapter. Thank you. Okay, so with this I have concluded 3 chapters, which is half of your syllabus. So the other parts we will do it tomorrow. Okay, the other parts we will do it tomorrow. I've gone through the past exam questions. I know what type of questions. I'm covering all of them. Okay, so in case if you want in depth and please go and enroll for the dream batch. It will help you immensely. Okay, it gives you access to all the paid lectures in like 300 rupees. So please do that. Get access. Unlimited views are there. You will be able to cover every single chapter in depth. So that is it, guys, for today. Thank you so much for your patience, for being there. Do like the video, share it with your friends, especially for students who are in South India. Lectures are in English, especially for you all. So please share it and give a shout out. Okay, let people know that such lectures are there. And thank you so much. Take care, guys. Bye. Have a great day. Study hard.